Right, welcome back everybody. And next we are excited to have Salome talk about her paper on confronting inequality in the theory of data law. The floor is yours, Salome.
Great, thank you. Yeah, so my name is Salome Viljoen. I'm currently a postdoctoral legal fellow at NYU Law. I'm also joint in a digital ethics group at Cornell Tech. And I'm going to be talking about legal theory today, particularly the normative legal theory behind why the law regulates how data about people is collected and used, and how inequality does or does not feature in our legal theories of data regulation. So in particular, I'm going to be discussing the disconnect in how we think of the project of regulating data flows and problems of social and economic inequality. And a quick note here, when I say data flows in this talk, I really am using that as a shorthand for data about people. So data that is collected about people as they live, work, travel, shop, use things, socialize, and just sort of otherwise go about their lives. And I'm going to walk through the implications of how data governance law encodes entitlements to data, how this endeavor can both misconceive of the problems of inequality to be addressed, as well as place roadblocks in front of how data production may itself be an egalitarian project, and how the law may inadvertently get in the way of collecting and using data to further the study of inequality and to address the inequality of current social and economic systems. So hopefully I'll also connect all of this legal theory to the work of computer scientists and economists and other social science researchers that use computational methods to study and address inequality. So to do that, here's a rough roadmap of what my talk hopes to cover today. I'm going to be talking about why legal theory matters, what some of the predominant approaches, theoretical approaches to data governance are thus far, why inequality should matter to data governance law. Going to evaluate some of the predominant approaches that we have, and then I hope to conclude by sort of prompting my scholarly community and all of us as researchers who care about inequality to take inequality seriously in our legal theories of information regulation. So first, why does legal theory matter? And I want to start here with the example of a legal scholar that I admire a great deal, Gary Peller. And Gary Peller is a critical race theorist, and he wrote this piece, Race Consciousness, in the 90s. And the 1990s, I think he wrote this in 1990, actually. And that was a time period in the US where the sort of conservative US Supreme Court was kind of using anti-discrimination law to undermine and dismantle a lot of the major civil rights era legal victories of the 1960s and 70s. So integrative busing requirements, robust affirmative action laws in employment and education. And Gary Peller sort of revisits in this sort of moment of the 90s two competing theories from the civil rights era that diverged in their diagnoses of what the wrong of anti-Black racism was, and hence what the appropriate legal responses to that wrong might be. And in this piece, Race Consciousness, he distinguishes between the race-conscious theories of Black nationalism and the race-blind or integrationist theories of civil reformers that ended up sort of prevailing in our legal response of the civil rights era, and that really gave birth to the forms of anti-discrimination law that we see everywhere today, both in algorithmic settings and beyond those settings. And in the piece, Peller explores how this translation of that political and social movement for racial justice into these race-blind as opposed to race-conscious legal agendas, in turn, really kind of set the terrain or resulted in a set of affordances in our existing US anti-discrimination law. And these affordances equated Black nationalist race consciousness with white supremacist race consciousness. And it's this equation of race blindness that was weaponized over the course of the 80s and the 90s and still through the 2000s through to today by the very groups that the civil rights movement opposed. And this led to our anti-discrimination laws in Gary Peller's words, marking the limits of their own political project to achieve racial justice. So my talk is not about anti-discrimination law or the history of the civil rights movement, but it does share this larger understanding with Peller regarding the stakes of law's theoretical commitments. So how we conceive of and theorize social problems or social projects in law informs how we enact the legal agendas that enforce or address those problems. Now, there are a lot of theoretical complexities to this basic insight, but at its most simple, I take Peller's work to be a lesson in being conceptually and normatively clear regarding the job of our legal theories in a given domain. So being clear about understanding how a particularly socially unjust process works. So this means what empirical claims about the world that theory rests on, but also understanding with specificity what makes a given social process wrong. In other words, what political or moral claims about the world our legal theories aim to enact. So my thesis for the talk today is that in our prominent theories of why the law regulates data about people, we are not fully confronting the theoretical implications of data as a currency of egalitarian justice, to use a phrase from Jerry Cohen, famous egalitarian philosopher. And by this, I mean that both data production's role in materializing social and economic inequality and the fundamental role that data infrastructures will play in addressing that inequality are not really featuring in our legal theories about data governance. And in failing to fully confront those theoretical implications of inequality, our legal theories about data also, while well-meaning, risk marking the limits of their own reform. So first, possibly an obvious caveat, but because this is a mixed audience and contains a lot of non-legal people, I just wanted to be very clear about what I mean when I say a legal theory. So what I mean by a legal theory is a particular conception of how a political project is realized and distilled into a legal one. So legal theories often offer a particular diagnosis of what makes something harmful and a yardstick against which we could measure current law or proposals to change that law to see if they sort of live up to that theory. So it's a way of evaluating law. As a diagnosis, legal theories tend to lead to a particular agenda of reform that is attentive to the relevant features of the diagnosis of that theory. And again, sort of looks at various legal proposals or existing laws and how they measure up on this yardstick. So what I do not mean are actual existing laws, which may embody any variety of different theories or may, be measured and evaluated against different theories. So for example, we have the Constitution, which is a US law, that is distinct from originalism, which is a legal theory of how to interpret and enforce the Constitution. So originalism offers us a way to evaluate and distinguish correct or incorrect, better or worse readings of the Constitution. And originalism gives us a way against which we could evaluate proposals for reform to constitutional protections, whether or not such. Sorry, go ahead.
So just as a clarifying question, so how do you think about the difference between a legal theory and, say, philosophy of justice or theories of justice? Are they basically the same?
Yeah, so, oh, and thank you for reading out. I'm not monitoring chat, so please feel free to interrupt me if you have clarifying questions. That's a very complicated, there are, as you can imagine, much ink has been spilled on the difference between a normative legal theory and a political theory. Here, I would say that our legal theories are really looking at how we would translate or enact a particular political goal or social goal. So it really looks at, if political theories or social theories are ideas of what we ought to do in our world, legal theories are really looking at, okay, what do those implications or what do those lessons mean for how we would evaluate our laws or craft our laws and seek to enact those theories of justice in the world in the forms of our legal code. So in my interpretations of them, I tend to think of them as very closely related, but not all legal theorists take that view. That's a contested view.
Thank you.
Yeah, you're welcome. So now we're going to turn to some predominant theoretical approaches that we see instantiated in the law of data governance and in proposals for how to reform such law. So the first sort of predominant theory that I want to review can sort of be characterized as the legal notion of the right to be let alone. Now, the right to be let alone features very prominently in US privacy, and given that this is the name of an article that is sort of considered to be the origins of US privacy law, written in 1895 by future Justice at that point, Brandeis. And he really kind of characterizes the right to privacy that we ended up having in the United States as this right to be let alone. But this sort of notion of privacy can also really be seen in large parts of EU data protection and privacy law. And the idea here is that data governance in the form of privacy law or data protection law should aim to shore up this sort of individual sphere of sovereignty and autonomy that we have against kind of external influence. So the theory of harm here is that excessive data collection or wrongful data collection and surveillance may undermine or pierce this legally protected sphere of autonomy that we all have around ourselves. And this is intrusive and creepy. It can undermine the dignity of the relationship we enjoy with our inner selves and sort of thwart the necessary kind of close relationship we have with our own inner desires as we sort of form them and come to know our inner lives. But more problematically, this sort of violation can also undermine our autonomy. So if we are subject to coerced consent via dark patterns, this can undermine our self-will and our enactment of that self-will. And the concern here is companies or other entities using behavioral surplus or all of the capacities they have to sort of nudge us towards other behaviors to internalize the goals of surveillors in the surveil and replace our own sense of self with a more programmable, predictable, or manipulable alternative. And so here again, there's really a normative notion of a sense of wrongful legibility, that we're being rendered legible excessively or against one's will. This in turn leads to a legal agenda to sort of shore up or strengthen that sphere of autonomy that we have around ourselves. So this tends to look at how we can establish stronger forms of consent to sort of try to legislate against forms of dark patterns or really make sure that consent is meaningful, as well as to grant data subjects more downstream rights against companies with respect to how information about them is used. And all of those sorts of legal agendas are really meant to reassert the protections that data subjects have to preserve the dignity of their inner lives and expand the protection of individual autonomy against various kind of manipulable or manipulative or coercive uses. So again, limits on how information can be used to profile a data subject or nudge them towards decisions that data subjects otherwise might not make. And so you tend to see these kinds of agendas in things like bans on adverse automated decisions, increased transparency about how information about data subjects will be used, more rights for data subjects to sort of expand their control over how data about them is collected and how data about them is used. The other kind of predominant theoretical approach to understanding data governance is really this idea of a right to payment. So Andrew Yang, who's currently running for mayor of New York and was a presidential candidate here in the US, as well as Sir Tim Berners-Lee, are both sort of proponents of this kind of theory or view that what sort of the wrong of data governance is one of unjust enrichment. So the point here is to assign data subjects a property right in the data they generate. So they become data owners, property owners, and sort of reassert their property ownership over this valuable resource. So again, here, the legal agenda is to grant data subjects an entitled asset right that they can then sell their data in a market for a price and get money from the sort of techno-feudalist data companies here for the data that they sell. And the idea here is to reassert that ownership right, gives data subjects the ability to command this price and sort of equalize the feudal relationship between data subjects and data collectors. So before we jump into analyzing how these predominant theories do at confronting inequality, I want to quickly pause here to talk about why confronting inequality in data governance law is important. After all, we have many areas of law. So why is it the job of this legal regime to represent, let alone address, inequality? So first, I would point to this chart here. It's a little outdated at this point. I pulled this from the web in February, but in broad strokes, I believe still holds. And the idea here is that data extraction, data collection is part of the story of unprecedented concentration of global wealth and power today. I think we all know the pandemic has been a real boon to tech monopolies, helped create multiple US centibillionaires. And as you can see from the chart here, many of them head up very data intensive companies. So Jeff Bezos, Elon Musk, Bill Gates, as of February of this year, were each worth more than $100 billion. And Mark Zuckerberg at 96 billion is quite close. Prior to this year, Bezos was the only US centibillionaire. He reached that peak in 2018. And if we stick with Jeff Bezos, his wealth grew from 113 billion on March 18th to 189.3 billion, an increase of over 2/3. And if you add his ex-wife, Mackenzie Scott's wealth, the two of them had a combined wealth of over $250 billion. So to put that in more context, if Bezos' $76.3 billion of growth in wealth was distributed to his 810,000 US employees, they would each get a windfall bonus of $94,000, and Bezos would not be any poorer than he was a year ago. So all of this wealth creation, for me as a legal scholar, in and of itself raises questions about whether it's socially desirable for one individual to have discretion over how we allocate such a huge amount of resources. We face choices about the legal arrangements by which we allocate claims to this wealth, and how we place boundaries or don't on how such wealth can be spent or passed down to children, how such wealth is or isn't taxed. And these are all policy choices. These are legal choices that we make, and we could make them differently. It's also far from the case that this wealth was come by innocently. I think we all are familiar with the stories of wage depression and the erosion of worker protections that facilitate this wealth concentration. Long history of anti-competitive muscling out and buying up of competitors that's going on here, and companies that are operating at a scale and with designs that facilitate communication patterns that have been harmful to global projects of democracy. And the concern here is that the more powerful these companies and their leaders become, the more they can exert their social and political influence. Now, all of this isn't just a result of extractive data collection practices, but it is well established both by the tech industry and tech industry critics that extensive data extraction is a key input, a foundational part of the digital platform business models. So how digital platforms secure consumer surplus from their consumers and other customers, and how digital platforms lock in competitive advantage over their competitors. So this makes data governance law not just the law of interpersonal relationships that sort of governs my relation with another person, maybe a nosy neighbor or a peeping Tom, but also makes data governance law sort of a primary legal regime that's setting the rules of this economic production and governing a key input of the information economy. So in turn, how we encode entitlements in law will affect the economic properties that information has, the sets of incentives that develop around that resource's exploitation or use. And this is, I believe, particularly true of intangibles like information that have no material properties constraining their use absent their legal and technical materialization and instantiation. So doing something about the digital economy that generates this kind of distortionary wealth concentration will require doing something about how these companies collect, process, and use data. But information production is not just an issue of economic inequality. In an increasingly digital and enduringly unfair world, datafication represents one material process whereby a great deal of social injustice happens. So how we become drafted into the project of one another's oppression. Data flows trace the relationships between us and tech executives and venture capitalists that grow very wealthy from surveilling us. But it also groups and classifies us in ways that can enact the societal relationships between us. So information flows can materialize social processes of racism, sexism, xenophobia, and other group-based oppressions in new digital forms. And so here I'd like to consider a recent story by the journalist Joseph Cox, detailing how the US military purchased granular location data from a popular Muslim prayer app with over 98 million downloads worldwide. The app, Muslim Pro, pings its users 5 times a day with reminders to pray. It uses a compass to orient them towards the Kaaba in Mecca, and it uses services to observe fasting during Ramadan and guides users to halal food in their area. So these features helped to turn Muslim Pro into the most popular Muslim app in the world, but it also meant that the app collected high-quality movement data about its users, since it relied on location tracking to orient prayers and recommend nearby halal food. So the revelation that movement data for Muslim Pro was being sold to the US military and was now in the hands of the US military sparked dismay and condemnation in the Muslim community. The Council on American Islamic Relations, the US's largest Muslim civil liberties group, sent letters to 3 US House committee chairs asking them to investigate this incident, and they called for legislation in response. Imam Omar Suleiman, who's a prominent Muslim scholar and founder of the Akin Institute for Islamic Research, told the LA Times this sort of tradition of surveillance is not taking place in a vacuum. He noted the long pattern of crackdowns and all sorts of violations of Muslim civil liberties that Muslim community leaders have sort of been pointing out for a long time, and connecting to the violent history of Muslim faith-based surveillance, particularly the expansion of the US drone program under President Obama, which used drones for surveillance and targeted killings in Muslim-majority countries and resulted in hundreds of civilian deaths. Zara Ballou, a civil rights attorney and executive director of a San Francisco area chapter of the Center for Islamic Rights, called the revelation about Muslim Pro's data sales a betrayal from within our own community. So the responses from the Muslim community leaders here reflect the social, not merely individual, significance of these data flows. This instance of datafication is wrong to them because it drafts users, faithful Muslims, into the project of their fellow Muslims' oppression. So it takes a digital means for expressing and enacting their faith and transforms that into a vector for what they view as an instance of imperialist violence, materializing this larger social process whereby Muslims around the world understand their tense relationship between themselves as members of this religious group and the US military that has historically and continues to target that group. In other words, what makes this particular instance of datafication, this data flow from Muslims to Muslim Pro to the US military, wrong is that it becomes a material expression of an unjust imperial relation between Muslims and the US military. So how do our predominant theories of data governance stack up on confronting these sorts of 2 forms of inequality that we face with respect to data production? So first, the right to be let alone, or kind of the privacy theory of data governance. What does it really have to say about economic inequality? Not much. In fact, reducing our claims or our sort of legal rights to information to claims about individual selfhood to monetary redistribution would violate a lot of the normative commitments of this theory. The sort of impulse here is that dignitarian protections are really about anti-commodification. These legal rights tend to be against ideas of reducing data about people to monetary assets. So addressing the relationship between you and a giant company tends to take the form of rights to opt out and against certain downstream uses, but not really rights for payment, which would kind of commodify information that goes against basic normative commitments of this theory. The theory also tends to address this relationship in terms of negative rights. So it gives people, again, rights to say no to certain forms of data collection, but it doesn't tend to give data subjects assertive, positive rights about what sorts of information flows they're subject to, or sort of give an active recognition in how information goals are set. So there's nothing really in the theory of the dignitarian account itself that finds the centibillionaire situation per se wrongful. If these data flows were obtained via gold standard consent, and it was only used sort of in accordance with data subjects' goals and views, there would be nothing per se wrongful about, Mark Zuckerberg or Jeff Bezos or Elon Musk amassing lots of wealth in the process of doing so. On the claims of social inequality, if we consider again the Muslim Pro example, under this kind of dignitarian or autonomy account, the data flow from a user to Muslim Pro to the US military might be diagnosed as wrong because a user of the app would be spied on by a government whose presence in their religious life might have a chilling effect on their activities. And had that user been notified or given the option to opt out of that transfer of data, they would almost certainly do so. This theory or diagnosis of what makes that data flow wrongful, however, says nothing about the larger social and historical context in which this datafication process is happening. It also says nothing about the relational rather than individual nature of this harm, by which I mean how the coerced consent from one user drafts them into the surveillance or potential bodily endangerment of another member of their community. So this data subject dignity account is unsatisfactory to explain the larger social context that makes the sale of Muslim religious activity data to the US military a particularly meaningful and significant act. If we look at the right to payment, credit where credit is due, the right to payment does offer some response to the idea of this unjust enrichment of free data extraction. However, given the realities of this data setting, there are several practical and empirical reasons to be skeptical that individuals alone can meaningfully exert the kind of bargaining power necessary to extract more than a nominal payment for their data. We're talking about data subject groups that are extremely fragmented, bargaining under conditions where an individual's data has marginal value of almost nothing to any given data collector. And again, this setting or this set of exchanges is subject to all of the same concerns over dark patterns and coerced consent that we see in the status quo. More troubling, I think, for this particular theory is this account's prospects for the social inequality problems that are materialized by data flows like the Muslim Pro example. So under this non-payment account, the data flow from a user to Muslim Pro to the US military would be diagnosed as wrongful because users were not being paid by the app or the US military for their data. So if the sale of this data is making Muslim Pro money, then users deserve some portion of that profit. This account, again, says nothing about the larger social and historical context of this data flow, nor of the relational rather than individual nature of the harm. So again, how a coerced consent from one user could lead to the surveillance or endangerment of another member. Even worse, payment might exacerbate the social inequalities materialized by data flows. So payment incentivizes those users that feel that they have nothing to lose or that can sort of benefit from sharing their data for profit to take advantage of that. But this in turn places those with everything to lose or that don't feel safe sharing the information in greater danger. So this increases the benefits to surveillance's winners, those who benefit from its conveniences and personalization, while doing nothing or worsening the risk of harm faced by surveillance's losers, those who, due to their social positions or group memberships that they occupy, face far increased risk of violence, discrimination, or adverse outcomes as a result of these data flows. So to return to the thesis of the talk, that predominant theories of why the law regulates data, we are not fully confronting the theoretical implications of data as a currency of egalitarian justice. Most troubling about the conceptual shortcomings of these theories is that they begin from an assumption that their egalitarian implications, by which I mean how data flows might produce winners and losers, set the stakes of winning and losing, how data production might materialize inequality, that all of this is marginal to the task of data governance rather than central to that task. And in failing to fully confront those theoretical implications of inequality, these legal theories too risk marking the limits of their own reform, resulting in marginal, if any, egalitarian effects. So how might we do data governance law differently? So current theories of data governance, I believe, are sort of faced with three inegalitarian or egalitarian risks. First, laws that are ineffectual against current forms of economic and social inequality being materialized via data production. And so here the idea is that because we're not capturing relevant interests in our data flows and representing choices within that exchange, we are not giving citizens standing to set those structural conditions that determine how those exchanges are set. Second, we have to worry about weaponized individual rights. So here, there's a long tradition, and we're currently seeing it right now in the US in our First Amendment jurisprudence, the affirmative action issues that Gary Peller was writing about, that this isn't really an issue in our data laws now, but the two sort of theories that I highlighted here sort of both risk or are both perfectly amenable to being weaponized by corporate or other powerful actors. So under that dignitarian or autonomy account, you could sort of analogize to how First Amendment freedoms of expression and religion right now are being wielded by companies to dismantle regulation. So similarly, we could imagine strong dignitarian claims about wrongful legibility or coerced legibility being used by companies against the state to dismantle forms of reporting requirements, regulatory reporting requirements that they might be subject to. And if we take the sort of right to payment account or the property account, we can analogize to Fifth Amendment takings arguments. And so these are constitutional arguments that are wielded by companies to resist turning over valuable property assets. And again, if we think of information as property, you could imagine companies using those sorts of proprietarian rights to argue that governments turning over or requiring them to submit information to public authorities or to public research institutions constitutes a Fifth Amendment taking. The third inegalitarian risk that I want to sort of raise here is that misconceiving our data governance laws can risk foreclosing socially beneficial data production. So again, because our law isn't necessarily capturing relevant interests in data production, both in terms of how priorities are being set by companies and how data protection rights are being exercised by data subjects, we could result in the underproduction of socially valuable, even vital information resources. So for instance, if we want to track CO2 emissions or water usage for climate research or resource management, we may not want to defer to really strong forms of individual consent of climate skeptic people in the US if we actually think that there are sort of global geopolitical justice issues at stake in tracking things like the CO2 emissions patterns of people in a very resource intensive country like the US. We may think that the rest of the world's people have just as much, if not more, of a stake in these sorts of data flows. And if our laws don't represent all of those stakes in our data flows, they may not really be adequately represented in how we set our priorities or determine whether or not this type of data flow is permissible. The other notion here is that information and public data infrastructures will likely play a key role in retrieving spheres of life from private market governance. So if people or reformers are of the view that private market governance is not the best way or the most egalitarian way to allocate things like housing, healthcare, and education, then retrieving those forms of allocation from private market governance will necessarily require some positive theory of data production in order to facilitate the allocation and distribution of those entitlements or of those benefits. So taking these tasks as central results in a very different kind of theory of data governance. I offer one sort of theory of that by conceiving of the task of data governance law as setting the terms of our data social relations. And this is an application of relational egalitarian political theories and a long legal realist tradition of focusing on law's role in structuring our social relations. And it takes seriously or sort of aims to represent both the vertical relations between data subjects and data collectors, as well as the horizontal relations between data subjects and others that they share relevant features with, and that make those features sort of relevant to the task of governing data governance, or governing data. The theory of harm here is that not this violation of personal autonomy or a right of payment, but what these data flows materialize. So whether these data relations materialize unjust social relations of oppression, domination, or exploitation. And it also has a distinct legal agenda. This legal agenda favors institutional forms of data governance that aim to represent far more interests in data production and aim to represent those interests in a relation conscious way. And so this sort of aims to develop priorities and controls that are set for information production that may look quite different from what we see today. So this may result in banning many forms of data production, absent highly controlled settings and legal and technical safeguards against purpose creep. So here we could think of things like biometric marker information or genetic information. It also might look like democratizing other forms of data governance. So here we could imagine things like workplace data or municipal data. And finally, it might facilitate and encourage other kinds of data production that we're maybe not producing enough of right now. So here one might think about, again, climate data, fine-grained details about people's resource consumption patterns, or also far greater information and clarity in international financial flows. Hopefully this also sort of suggests why getting our legal theories right is a sort of a good segue or bridge between the agenda of legal theorists and the agenda of economists and other researchers who aim to develop egalitarian responses to the current world. The current status of our data relations are largely unequal, but like our analog social relations, they don't have to be. Just like data can materialize injustice, our data flows can also materialize just social relations. And like the law itself, data relations will likely play a key role in facilitating how we address inequality in the digital world. And that includes much of the machine learning research being discussed here. There's also here a central normative egalitarian agenda to this legal theory, just as there is to this line of inquiry or computational research, that the goal of data governance law should be to develop legal institutional responses that equal these relations, and that in turn foster the egalitarian role that data can play in equalizing other areas of life. So with that, I'm going to stop my screen share and hopefully open the floor up for some questions. Thanks.
Thank you, Salome. That's great. Who wants to go first? Let's go first again. Oh, hey, Abby, go ahead.
Hey, great talk. Great to see you.
Hi.
I was wondering, you mentioned a little bit sort of like the relational power within these. Could you talk a little bit more about that?
Yeah, so actually the paper that this talk stems from spends a great deal of time talking about why sort of this relational aspect of information production that currently doesn't really feature in our theories of why we govern data it is very central and should play a far more central role in how the law thinks about representing interest in information. So by that, I'm kind of making an empirical claim and then also a normative claim on top of that empirical claim. And the empirical claim, to start with that, is that when data is collected about me or from me, it is never simply just about me. So you can collect data about me and it's like, okay, Salome, she's a woman, she's a millennial, she's a cat lover, she recently bought her cat an expensive Japanese ceramic cat bowl. That isn't just sort of used to make predictions about me and my consumptive behavior. It's also used to say, okay, there's this other millennial woman out there. She's maybe also likely to buy this cat bowl. And so when we're thinking about the interests that I have and how my, millennial woman cat loving data is being collected, I'm not the only one with a potential stake in how that information is going to be used. People who share these relevant features with me also have a stake in how that information is going to be used. And so legally, when we try to reduce all of the interests in that information just to me and my sort of contractual relationship with whoever's collecting that information about me, Google probably in this example, there are all sorts of relevant interests of other people that our law just isn't representing. And so it's not featuring in how we think about what kinds of information we allow, what kinds of information we disallow. And that's kind of the general empirical insight here. Where I think that sort of glosses into a normative insight is to say, we have issues of lack of representation, so different interests aren't being represented. But that doesn't just flatly implicate all sorts of people equally. It's one thing when we're talking about like my millennial cat bowl purchasing. It's very different when we talk about, let's say, information about whether or not I'm in the first trimester of a pregnancy. And now that's going to sort of implicate very different kinds of social facts about me that may be far more vulnerable. And in turn, if that makes someone else, a prediction about someone else's first trimester pregnancy more likely, or sort of facilitates those sorts of predictions, we're dealing with like normatively distinct kinds of concerns with respect to those sets of interests not being represented and how we think about how we regulate and allow that kind of information to be collected and used.
Right. So I guess I have a big question also, which is like, I guess when I think about machine learning or AI more generally, I guess you can think of a lot of it as optimization or maximizing some objective function. And then I guess like control rights over data or ownership of data really translates into picking the objective function, right? If Facebook controls the data, then Facebook uses it to maximize ad clicks or whatever. Mm-hmm. And so I guess I was wondering if you have thoughts about possible alternative legal regimes in terms of redistributing the control rights over data, what that does in terms of changing the objective functions that actually used AI is used for.
Yeah. So again, I think that when we take far greater interests, when we sort of represent a far greater set of legal interests in how we think about governing information, one thing that very naturally follows from that is that the set of information that we would allow a company to make exclusive, their goals and their priorities, to set sort of the exclusive agenda for how that information is collected and managed and used, and towards which objective functions we're optimizing, would probably shrink a great deal. And so that looks like forms of governance that sort of represent far more interests in that information. And so what that specifically means in terms of a legal agenda can depend on the kind of information we're talking about. So that can translate into a legal agenda that says, okay, Facebook has a limited monopoly interest in the information that they collect. They can exploit that resource exclusively for 5 years. After 5 years, that information reverts into a public institution or public data institution that manages that information, and that researchers can apply to gain access to and can explore all sorts of other social questions, or competitors perhaps can gain access to that information and try to develop competing products. But we no longer, as a sort of state, recognize a sole ownership or proprietary claim in one company to determine the how that resource is going to be exploited and used. Another form that it might
your
take,
ideal would be like public ownership of or public repositories of data, or
for certain sorts of information, but in other settings, information sort of institutionalizing a greater set of legal interest in information might look like giving labor unions an explicit bargaining right over the forms of workplace surveillance that they're subject to. So you could expand the sets of labor protections that we have to say that one thing that worker unions can bargain over are the forms of surveillance that they're subject to, and in turn impose onto their employers. So that might be the form that you might see for institutionalizing a greater set of legal interests over workplace data. You could imagine municipal data that if a ride-sharing company wants to operate in the city of Ann Arbor, where I'm based, they have to apply for a license from the city first, and all of the information that is collected needs to go through an intermediary that sits at that municipal level data kind of repository, and the city can use that to study their traffic information, set priorities for how they're going to develop and invest in infrastructure, and maybe reevaluate whether or not allowing these companies to operate in the city is good or bad for the various political goals of the city. That's another way that it might look. So it really kind of depends. But the basic idea theoretically is that these interests are not reduced to that individual exchange between a data subject and a data collector. There's a lot more happening here.
So like having collective institutions that manage them.
Yes,
in some form or
far
other.
more collective institutions. Yeah.
Abby Adams.
Oh, we have two Abbies.
Yeah. I'm sorry if this is a stupid question, but I was wondering, so you're talking about data collection a lot of the time, and some of the kind of problems that you identify seem to be more about the way that the data is processed. And of course, the way, like, the ownership and the way data is collected is likely to influence the way that it's processed, because people are going to have to give different types of consent. But it kind of seems that they are logically distinct, and like there are certain things, how can I put it? I guess what I'm thinking about is, you know, in a more benign setting. So I'm thinking about data like administrative data collected by the state, which at the time was kind of is like secondary to the core purpose of data, of why particular forms of data was processed, as it was collected in the first place. But ex post has actually become really important for understanding particular phenomena, like from the perspective of research. And so that would point more at being concerned about processing as opposed to collection. I was just wondering if that was a silly distinction, or how you thought about it.
Yeah, no, I mean, there are people who get into all kinds of nitty gritty about, like, do we regulate data collection? Do we not care about data collection? We only regulate data use. I tend to really think about them as deeply interconnected, and I tend to take a holistic approach. So I'm probably flitting in this talk between, like, looking at data collection, looking at data use. I tend to think that the normative relevance that goes into how we would restrict or set the conditions of data collection are inextricably entwined with the uses that we anticipate for that information. And yeah, let me think back a little bit on your question. I mean, I also think that, I mean, one of the benefits of sort of thinking more institutionally about information is that you don't kind of have to break it off into this like one-off thing where you like either give your consent for it to be collected or not. You can tend to think about managing information production, information resources with an eye to, okay, if you want to use this to measure impacts on climate, go ahead. If you're going to be trying to create like a competing industry with the company that we gained the repository of this information from, maybe we have like we hold you to a higher standard, or we regularly check in to make sure that you're not using this information in an inappropriate way. So you can start to think about kind of tiering or managing your access to information based on the goals or the purposes of use. But you can also start to think about how you would implement those sorts of institutional controls around different kinds of information being collected. So again, you could think of information being collected around workers or in the workplace, going to a different kind of institutional repository to make those decisions about use that might be distinct from the types of institutions that are sort of managing and sort of setting the priority of those questions if we're thinking about like the municipal public trust. So that was a little bit of a jumbled answer, but I think what I'm trying to get at is that I think both collection and use are normatively important for the law to think through in terms of how that hashes out, in terms of, you know, what interests we represent and how we represent them. But I tend to think that collective institutions offer us a more coherent way to kind of like balance the interests we might have at the point of collection and balance the concerns or the goals that we might have around use.
No, that's really helpful. Thanks.
Yeah, thanks.
Abby?
I'll have plenty of time to talk in a minute, but I just wanted to mention I guess this relational level of, and thinking about sort of intervening on collective institutions, if you're thinking about that as a way to sort of intervene on markets. I'm also thinking about sort of like Lena Kahn's work on Amazon, if this is a way to sort of, if this points to sort of like an empirical strategy to think about how we sort of potentially measure harms.
Yeah, absolutely. I mean, I think that thinking about our rights to information relationally or collectively one just like empirically maps on to how information can benefit and harm people. Two, I think it also goes more accurately represents the way that information creates forms of outsized market power for certain companies. And I mean, to be honest, reverting large stores of information resources that are currently being legally defended by like a weird and flimsy reading of trade secrecy law into the public right, into the public domain, or in various forms of sort of collective institutions would significantly undercut a lot of the sort of monopoly power that these companies currently enjoy. We can have a long discussion about how I think antitrust approaches do and do not achieve that, or how they kind of interpolate into an agenda for developing data institutions. But yeah, maybe I'll leave that there for now.
And to be mindful of time, the last question is Ruben.
Thanks.
Hey, Ruben.
Hey, thanks. I'm a really big fan of the paper that this talk was based on, and the talk really helped illuminate some of the issues, and you brought some interesting new examples to the table. So thanks for that. And my question is about like to what extent is your argument kind of based on a critique of data governance from a rights, sort of, I guess, individual rights perspective? Is it that like some of these values could be better protected if we move away from an individual rights perspective? And I guess thinking about like other critiques of even individual rights, which are supposed to protect kind of egalitarian norms, like, you know, rights to education or healthcare or things like that, is part of your argument that like trying to think about egalitarian data governance in terms of individual rights is the problem, or is it something different to that?
Yeah, I mean, I always joke this paper has undergone a painful metamorphosis from a political philosophy paper into a legal theory paper. And in its earlier larval state as a political philosophy paper, it was absolutely engaging with a lot of work that sort of it is a critique of an individual rights approach. I think in its current form, it's less a critique of individual rights and more a critique of individual data subject rights. By which I mean that you could very well say that we all have like individual political rights to mutual self-determination of our data institutions. And those are individual rights of political standing and political recognition in setting the priorities of our information resources, to which purposes they are being used. That tends to sort of govern all of our political institutions in a liberal state. But they're not individual data subject rights. They're public rights. So we all have standing. And, you know, again, here you could say we all have standing in the mezzanine level institution as workers. We all have standing in the mezzanine level as like people who may become pregnant. You know, you can break that into mezzanine level institutions or groups. But as a legal agenda, it still probably contemplates individual rights. They're just different kinds of individual rights, political rights, as opposed to kind of personal or transactive rights.
Thanks, that's really interesting. Thanks.